is Brad Williams. I'm one of the attorneys at Holland & Hart who will be presenting today. It's just now 12 o'clock. We have about 8 people who've joined us. Why don't we give it a couple more minutes to see who else may join. And if more people don't join, that's actually probably good for us. You know, one of the reasons we wanted to do this was to keep this small so that we could really have a conversation with people and hopefully answer your questions. But why don't you hang tight for another minute or so, and then we'll get going. So we've just had a couple more people join. Why don't we start? We'll start with some introductions, and then some more people may join us in the next few minutes. But welcome, everyone. Thank you very much for joining us. We appreciate you taking your time today. What we're doing today is the 4th out of a series of webinars that we've been doing with the ACC over the last few months. And I'm hopeful that some of you, or maybe all of you, have joined some of our previous seminars. What we did in the previous seminars was go over a lot of the new laws in Colorado that went into effect at the beginning of the year. I see we have a few more people joining. What we're doing with this webinar is trying to keep it small. We had a restricted invitee list. We've got about 13 people right now. I think we may get up to about 20 or so, but we don't want to recover the ground that we went over in our previous webinars under the assumption that many or maybe all of you were able to attend. What we'd really like to do is have a discussion with you today, try and answer your questions about topics that we've addressed before, and see if you have specific questions you'd like to ask us. And so throughout the presentation today, we'll be putting up some poll questions, which you'll see on the right side of your screen to sort of start sparking discussion on various topics. But please do interrupt us at any time. We are open to talking about anything on the topics that you want to talk about today. We want this really to be a roundtable, as it says below, not just us talking to you. So everyone should have full control over their mute buttons on the bottom left. If you want to unmute yourself at any time and jump in and ask a question or say something for the good of the group, absolutely do so. With that introduction, let me tell you who will be presenting today. You see Kevin Seltzer. He's a partner in our employee benefits and tax group here. He's going to actually give you a little bit new information that's come up since the last webinars about incentives that you may be able to provide for vaccines, a little bit of information about some tax credits under the new COVID relief bill. And then you see Deborah Hake as well. She's a colleague of mine in the Labor and Employment Group here at Holland & Hart. Deborah will be talking about the Equal Pay for Equal Work Act, which, as you probably know if you joined some of our other conversations, is a new act that both prohibits pay disparities between men and women, but perhaps more pertinently to us, has pay transparency rules, specific rules about information you need to put in postings for job opportunities and promotional opportunities. And my name is Brad Williams. I'm a partner in our Labor and Employment Group. I will be talking last, and I'll be talking about the HFWA, the Healthy Family and Workplaces Act. It's Colorado's new paid sick leave law, which went into effect on January 1. So with that introduction, and let me just say once again for anyone else who may have just joined us, please do interrupt us as we go on if we can answer specific questions for you. So with that, let me pass it to Kevin.
Thanks, Brad. Yeah, so as Brad mentioned, I'm a partner in our employee benefits group. We're a group of 8 attorneys and 2 paralegals, and we only work in employee benefits. And so what we do is advise companies on compensation and retirement plans, health and welfare plans, and exec comp issues. The things I'll be talking to you about today have that flavor with it. So I think I have presentation control. Let me see if we can advance the slides. Okay, so first thing I wanted to chat a little bit about is kind of a real hot topic at the moment, and that is employers kind of getting involved in incentivizing vaccines, the COVID vaccine. There's sort of some rules and laws that you need to be mindful of, and it's going to really depend upon how the employer wants to structure their vaccine program if they're going to get into this space. As to what laws apply and how those have to be structured and that sort of thing. But I kind of want to just quickly kind of point out some of the things that you'll need to keep in mind. So first up, I have Hipaa ACA, Affordable Care Act rules. So Hipaa has non-discrimination rules that were enhanced, probably the right word, by the Affordable Care Act that apply to wellness programs. And wellness programs are kind of generally programs designed to incent healthy behavior. So a COVID vaccine would very much kind of fall into that rule or that scope of rules. And those requirements, make the employer provide certain disclosures to participants with the COVID vaccines. It would, make the employer offer reasonable alternatives if an employee isn't able to get the incentive due to, for instance, let's say a health condition, they couldn't get the vaccine, so you would have to offer them an alternative. It also places, financial limitations on what the incentives can be. The next up is the ADA. Now, back in January, the EEOC proposed some rules regulating, these types of arrangements, wellness programs, COVID vaccines. Those rules have since been withdrawn and are being kind of analyzed by the Biden administration, but it's possible those come back, or maybe they're, more stringent when they come back. So, a lot of employers are sort of following those EEOC proposed rules out of an abundance of caution. And the main thing there is, if those rules apply, and we'll talk about that in a second, the incentive that you give to folks can't be more than a de minimis amount. And one of the examples in the proposed rules was, a small gift card. And so there's kind of this general thought that, $25, $50, $75 gift card may be just fine as a de minimis benefit. But going above that, depending upon the vaccine incentive structure, might be a problem, or at least could be problematic under the ADA. And then last, I don't have a bullet on it, but ERISA potentially applies to a vaccine program too. Any sort of arrangement where we're providing group health coverage or benefits or reimbursing and that sort of thing potentially implicates ERISA and all of its requirements, like having a plan document and a summary plan description and so forth. So before I talk about the kind of the structure of the vaccine program and my last bullet here on hands-on, hands-off approach, Luke, could you put up the poll? Great. Yeah, so this is a polling question, or I guess more of a polling statement about what you might be doing around a COVID vaccine and incentivizing or requiring that. So if you could input your answer there on the right side of your screen, we'll release that in a second. While you're doing that, let me just talk about what approach we tend to recommend, because it fits with what employers want to do often. And that is kind of what we call the hands-off approach to a COVID vaccine incentive. And what I mean by that is the employer wouldn't be involved in either administering the vaccine or contracting with the party to administer the vaccine. So think of like, an on-site, vaccine program. I know that's probably difficult given supply issues with the vaccine, but a hands-off approach would not be that. It would be, hey, go get a vaccine at the hospital or at your local pharmacy. Show us proof of that, and we'll give you some reward or incentive for that. That structure generally should not be subject to the ADA, so you don't have to worry about the de minimis limit. and it avoids some other applications, potentially ERISA as well with that structure. So that tends to be what we're recommending. Luke, do you want to release the poll results? Good. Yeah. So it looks like a lot of companies are saying no. we're not gonna go there with a vaccine and get involved in the incentive. And we have some that are doing an incentive of one that's doing an incentive less than $100, and two that are doing an incentive of more than $100. So very interesting. Before I move along to the next subject, do we have any comments or anybody want to talk about what they're doing for a vaccine program? All right, you'll have another opportunity, I promise. All right. So this is sort of an update I have here. Last session, we talked about, employee separations, and I talked about separation agreements and, the various types of components of pay you might have as severance in an agreement. And, and I talked about my distaste for having employer subsidized Cobra because it tends to invite some compliance problems. One is there are health plan non-discrimination rules. So if you're doing subsidized Cobra, particularly right now, if you're a self-insured plan, that could be problematic under those rules. Another potential issue is that it might set the individual up for having a hard time enrolling in subsequent coverage. So you might entice them onto your Cobra for a few months because of a subsidy, but then they may not be able to enroll mid-year in exchange or another employer plan because they want to drop the Cobra once the subsidy ends. And instead, what I recommended was that employers just do a taxable stipend, typically paid in a lump sum, but it could be paid in installments. And it's sort of like additional cash that the former employee can use if they want on health coverage, or they can use it on something else. It tends to be a little, less complicated from a compliance perspective, taking that approach. So with that recommendation, Congress stepped in last week with the American, I think it's Rescue Plan Act, the Arpa, and is providing subsidies. And unfortunately, employers are going to be required to provide these subsidies. There are some optional provisions of the law, but for the most part, it's required. So I'll tell you a little bit about the subsidy. It applies to only individuals that have had an involuntary termination of employment, or they've lost coverage due to a reduction of hours. If they're eligible, if you're one of these qualified individuals, you can get a subsidy between April and the end of September, and it's the full cost of Cobra that'll be subsidized. I call it employer advanced government funded because the way it works is, the employer would basically either be paying the premiums into the insurer, or if it's self-funded, they don't, pay premiums anywhere. They're just kind of covering it and not charging the employee. And then the employer gets a credit, a Medicare tax credit. That's how they get the refund for this new Cobra subsidy. And it's going to require employers to do a lot. They revised Cobra notices are going to have to be provided that talk about the subsidy opportunity. There's going to be a special Cobra enrollment period. So not only is this for people that are on Cobra from April to September currently, or will be, but you have to offer it to people that would still be in their Cobra period if they hadn't either declined Cobra or they elected Cobra but then dropped it subsequently. You have to give them a second bite at the apple to get back into this. So hopefully a lot of you on the call have good Cobra administrators and they'll handle most of this for you, but this is kind of a big issue and going to be a headache for the next several months. So it's going to be interesting to see how this goes. Luke, do you want to put up the next poll question? So the question is, what type of health benefit component to severance pay does your company offer? First, I have subsidized Cobra. What I mean is the employer subsidized Cobra, right? The employer's paying for some or all of the cost of Cobra. Or you offer taxable health stipend, like I mentioned, that's the cash payment. Buy coverage with it if you want, or use it for a boat. And then C is you don't do anything. So if you could answer that question, we'll release that in just a moment.
And Kevin, while people are answering that, I can tell you we've had a couple responses in the Q&A about what people are doing for vaccine incentives. Some people may have joined late. I'll let you know. Absolutely feel free to respond in the Q&A, or feel free to unmute yourself and speak up. We're happy to and would like to have a conversation with everyone. But I see there are a couple of comments about folks offering PTO for vaccine incentives.
Yeah, I have heard of that as well. I haven't worked on one of those arrangements, but I know some of my colleagues have. So I think it makes a lot of logical sense to do that. It sort of fits with the type of incentive that would make sense for getting a COVID vaccine. It would be interesting to know, how much of that is being done in a program that is, the hands-off approach, as I mentioned, right? And I would assume all of it is mostly being done in that approach. That way, you avoid the de minimis requirements of the ADA, and you don't have to worry, because obviously a day of PTO could be relatively valuable from a compensation perspective. Luke, do you want to release the poll results? Great. So it looks like quite a few offers employer subsidized Cobra. Nobody's doing the taxable health stipend, and there's others that don't offer a health benefit as part of their severance pay. So that's interesting. I wonder, Brad or Deborah, do you see a particular arrangement in your practice?
I have not. I don't have insights on what my clients are doing in this area.
Yeah, I usually refer my clients right to Kevin. So that's how I work with this problem.
Yeah, I will say on that, with the subsidized Cobra, I mentioned that there are non-discrimination issues potentially with doing employer subsidized Cobra. There's a few ways around it. One is you offer it to everybody across the board, then you're not discriminating against anybody. The other is you make it taxable. That potentially avoids the non-discrimination issue. And then the last is, if you have an insured plan, there's no non-discrimination rules currently applicable. There are rules under the ACA that would make non-discrimination rules applicable to insured plans, but those have been on hold since the Obama administration. It's very possible the Biden administration is interested in pushing those along, and those could be subject. Those could become law at some point in the next 4 years.
And I'm seeing a comment in the Q&A saying that the attendees are having trouble unmuting themselves. So we have a IT guy who's assisting with this webinar. Luke, if you can do anything about that, we'd appreciate it.
I'll work on that, what I can do.
Yeah. Anybody want to share who's offering subsidized Cobra? And maybe we can't with the audio problems, but what you're doing with subsidized Cobra? Well, as I look through the attendees, I see the mute on everybody. So maybe we're still having the audio problem.
Yeah, take a look, Kevin, at the Q&A. Someone's asking a question about Arpa, whether it's passed. And my understanding is it has.
Yeah, I've unmuted everybody, so people should be able to speak.
Yeah, I can hear some noises. I'm having trouble seeing the Q&A for some reason. Let me see if I can't get it. There we go. Brad, any chance you could relay that question?
Yeah, so so the last two are, there's a question about whether ARPA has passed, and I understand it has. Tell me if I'm wrong, Kevin.
Yep, last week.
Yep, and then there's another question or a comment, I suppose, saying that this employer is paying full Cobra. The length of time depends upon details relating to separation.
Yeah. Yeah, interesting. I have seen those arrangements that, you know, provide scaled health coverage depending upon maybe years of service, that sort of thing. So makes a lot of sense to set it up that way. All right, let's move along. Just real quickly, I wanted to mention the credits that were available for sick and family leave under the FFCRA were extended. Now the FFCRA required employers under 500 to offer, you know, emergency paid sick leave and the EFMLA through December of last year. That was extended through March of this year on a voluntary basis. So those employers no longer had to offer it, but if they did, they could still get the tax credit. Well, that's now been extended from the end of March to September. So and it's been modified a little bit to cover time to get back, cover leave for vaccinations or, you know, side effects and health conditions related to getting the vaccination itself too. So I just wanted to mention that development as well.
Can I go back to the subsidized Cobra with a question? So that's just for April through December that we need to fully subsidize it. Is that correct?
Yeah, and it's only for, I think that's Bridget.
Yes.
Hi, Bridget. That's right. It would only be the period April through the end of September, but it would only apply to people that have Cobra due to that involuntary termination or reduction of hours. So somebody that quits and leaves doesn't get the subsidy.
Okay, and so it's just if they're laid off or reduction of hours. So if someone goes out because of, say, long-term disability, and we would normally subsidize it, that situation isn't subject to full waiver of premium. It's just if someone is laid off or has reduction of hours. Is that right?
Yeah, I think you'd want to look at the plan to make sure that the loss of coverage due to disability isn't because of reduction of hours or something like that. But
no,
right.
Yeah, we would only code it if it's due to their own illness or injury. Okay, so just to make sure I understand this, so if we have somebody who's out on Cobra right now because maybe they got laid off last year or something, so they've been paying their portion of the premiums up until now, and so basically now starting from April to December, we just need to waive all premiums for that period of time, and then in January of next year, they would potentially start paying their portion of the premiums again. Is that right?
Yeah, so it would be through September. So in October again, they would start paying the premiums, right?
So just April through September. Okay.
Yeah, and there's some other provisions of the law, like for instance, and this part's optional, but you can offer people that are currently enrolled in Cobra an opportunity to change their coverage and not make it better, but decrease the level of coverage. So for instance, if an employer offers a PPO plan and a high deductible health plan, it may be, and you have a Cobra enrollee on the PPO plan, if the employer wants, I think it would be able to allow that enrollee to elect into the high deductible health plan or the lower level of coverage.
Let me jump in here. We have a couple comments coming in through the Q&A about asking everyone to mute themselves if they're not talking. I think maybe people are already doing that. We're not getting the same level of background noise. One more question I see for you, Kevin, here. Does ARPA apply to terminations due to poor performance? And if you wouldn't mind answering that, and then maybe we'll move on to Deborah so we cover everything. But I'll let everyone know that if you keep asking questions in the Q&A, we'll follow up after the presentation. Someone else is asking if they can print the PowerPoints right now. I'm not sure if that's possible, but if not, we'll also circulate the slides after this presentation.
Yeah, Yeah, so on the question about termination due to poor performance, the answer is going to be generally yes. I assume you're talking about Cobra there, the Cobra subsidy, but yes, it would be an involuntary termination of employment. There are some very limited circumstances in Cobra where you don't have to offer Cobra at all. Off the top of my head, I can't remember what those are, but they're really bad actor things like fraud and that sort of thing. So somebody that just isn't doing their job well would, if they're otherwise entitled to elect Cobra because they had group health coverage when they left, they would be eligible for the subsidy. All right, with that, Deborah, would you like to take us through some other slides?
Oh, you bet. All right, so I'm going to monitor the Q&A and the chat as much as I can. So bear with me though if I miss something. Maybe Brett or Kevin can help me out. So I want to start first with just a brief overview on the Equal Pay for Equal Work Act that went into effect January 1. It does two key things. The first is it says that you can't pay somebody of one sex different than somebody from another sex if they're doing substantially similar work. And we used to be able to justify pay disparities on a bunch of factors, and there was a catch-all factor that we could point to if nothing else fit. But now we're strictly limited to statutory factors. So these include a seniority system, a merit system, a system if you're measuring by quality or quantity of production, so number of hats that you're producing, geographic location, education, training, experience, but only if they're reasonably related to the work in question. And then finally, travel. And key here is that the statutory factors have to account for the entire wage differential. It's not enough that they only bring the gap up a little bit. The second big thing, which is created challenges for companies to implement, is these new pay transparency rules. So mostly about job postings. So now you have to post for promotional opportunities and give notice to any Colorado employee to whom that job would be a promotion. And then you have to reasonably communicate the notice. So maybe it's via email or your regular method of communicating with employees. You can even post it on your internal job board as long as employees know to look there for job postings. Okay, with the overview out of the way, let's dig into some of the content. When is it necessary to post? Well, you have to post for promotional opportunities. And the hot topic question that I keep getting bombarded with is, what about inline promotions? So in other words, what if you want to move Beth from customer service rep 1 to customer service rep number 2? But nobody's left at the level 2. This is just a straight trajectory inline promotion. So let's open that whole question, Luke.
Well, while people are answering this question, I can also jump in and say, incidentally, there is a lawsuit going on right now trying to invalidate the Equal Pay Act. It's in the federal district court in Colorado here. I just checked the docket this morning. There's a PI, preliminary injunction hearing, scheduled for middle of April. So that's interesting. Of course, unless the act is enjoined, you have to comply with it. But I wanted to let everyone know that that's in the offing. The theories in that lawsuit are some kind of dormant commerce clause theory where this interferes with interstate commerce, and then a First Amendment forced speech theory. Employers shouldn't be forced to put all this information into job posts, public job posts.
Yeah, we're definitely tracking that case closely. It was filed a few months ago at this point, and only until next month are we going to start to hear just bits of the merits. So that's going to be a case that takes a while to resolve, I would guess, but we're watching it closely. All right, Luke, let's close the poll questions. I'm really only interested in question number 1 since we haven't talked about question number 2 yet. But if people answered both, great. Okay, yeah, I figured no answer would be primary for question number 2. So people tend to work at companies with inline promotions. So how do we handle these? Do you have to post? According to the Colorado Department of Labor and Employment, the answer is yes. Yes, you do. So even though it's not a vacancy in an existing position, nobody's left, you still have to post because it's considered a vacancy in a new position. So if you are changing the title of an employee or materially changing their authority, duties, or opportunities, then you have to post. So does anybody see a problem with this interpretation and what this could mean practically speaking? Maybe you can unmute or just throw it in the chat. While you're thinking about that, I'll say that I've heard from companies that they're having issues with morale. So somebody may anticipate that they're going to get that inline promotion because that's what the company has always done. And all of a sudden the inline promotion has to be posted and maybe other applicants are also getting involved. And so employees' expectations aren't being met. Yeah, exactly. Just what Emily says. People are feeling like people outside the company are stealing their jobs. So some employers are thinking about removing all inline promotional opportunities altogether so they don't have to deal with the headache. I'll say this can be complicated just because you're no longer classifying people as levels 1, 2, and 3. If you're still materially changing their job duties along the way, the Department of Labor and Employment could consider that a promotion that you have to post for, even though you're not changing their job titles. Now, there are exemptions that employers are trying to implement along this inline promotional opportunity so that you don't have to post. So these encompass automatic promotions. So for example, you're automatically promoting somebody from this service rep 1 position to the service rep 2 position once they make 500 sales. It's a concrete number, automatic promotion. If you include a notice of this promotional opportunity in the handbook and you notify current and new employees that the notice is in the handbook, and then you have to update the handbook, of course, when there are any changes to the system, you don't have to post for that inline promotion. The other automatic exemption that can apply is if you automatically promote people to that level 2 after a trial period that's 1 year or less. And you have to put that commitment to the employee in some kind of writing. It could be their offer letter, contract, the handbook again. And then that automatic promotion has to be based on the employee's performance and or the employer's needs. So even though there's no blanket exemption to the job posting requirement for inline promotions, there may be ways to adapt your process so that they can fit into these automatic roles. Now, this may be easier in the manufacturing realm where you can measure quantity, or in the customer service realm, but it can be harder like for an associate attorney to move up to the next level when it may not be based on such concrete automatic objectives. All right, so I just want to briefly touch on the rest of the exemptions that may qualify. So one is for regular hires. So an employer is continuously accepting applications for, and then you have to hire at least one a month of a position. And you have to send a monthly email to employees, could be on the last day of the month, with the notice of the promotional opportunity. So this isn't the same kind of regular automatic vibe that the Department of Labor and Employment seems okay with. Another exemption is that if there's somebody in the position that you'd like to replace and they don't know that they're about to be discharged and you're worried about them taking confidential information or misusing company property in some way, you don't have to post for that position. And then finally is acting temporary or interim positions that last only up to 6 months. Okay, so my second poll question was, do you think any of these exemptions may apply? I feel like we can move past that and move on to the next topic, because I'm extra interested in what Brad's going to talk about too. So let me advance the slide.
I actually have a question related to equal pay. I don't know if this is the right time to ask or.
No, go for it. Happy to talk.
So my understanding is that the definition of wages is pretty broad, and it includes like commissions and bonuses and that kind of a thing. I would think that that would include a spot bonus also, even though that's a, you know, unscheduled, discretionary, rare kind of a thing. But I would think that that would get included. But then I started thinking, well, what about recognition, like where they give a gift card? I wouldn't think that would get included. So wanted to get your thoughts on what is and what isn't, you know, or does need to get included as we look at that, or is it anything that's in more of the recognition realm doesn't need to get included?
That's a great question. So this ties in perfectly to my first bullet here. So what do you have to include in that job posting? And I think you're talking about the second part, which is the general description of benefits. And the rules say you have to include all possible benefits that may be offered to the candidate, which includes sick leave, vacation, bonuses. But you don't have to list benefits that are considered minor perks. So if it's a de minimis spot bonus or a de minimis recognition bonus that somebody may get well in the future, it doesn't necessarily need to be listed in the job posting. And it's also okay to stick to that word general and to say you are eligible for bonuses or commissions, period, and to not get into the weeds on how exactly people need to earn those bonuses. But Brad, if you have additional thoughts on this question,
No, I think that's right. And I would add for the benefit of everybody, and I was going to raise this anyway when we talk about the HFWA, when you're dealing with these new laws, you know, the best sources of guidance that may address these issues, both for the Equal Pay Act and for the HFWA, are of course the Act itself, but the statutory language is a little dense. If you're not aware of it, there are fact sheets that the CDLE puts out. They're called info sheets, interpretive notices and formal opinions, I think is the acronym. But if you search, Google search CDLE info sheets, you'll find a lot of info sheets, both on the Equal Pay Act and on the HFWA, that really go into some of these in greater detail than the Act itself. Another really good source is the regulations that are interpreting the Equal Pay Act and the HFWA. Again, unfortunately, those are hard to find on the CDLE's website. But if you Google CDLE proposed/adopted rules, it'll take you to a page where you can see the regulations. So I say this all by way of saying that, you know, this specific question about what needs to be included in relation to compensation and benefits is addressed in some depth, particularly in the regulations that I urge you to take a look at. And then the fact sheets try to sort of summarize the regulations. But those are great sources to look at that'll help get you oriented on this.
Absolutely agree. That's where I get lots of my information. So the other part of what needs to be included in the job position, other than the benefits, is the compensation or the range of the compensation. And for this range, you can be relatively generous. You can put the range from what you're paying the lowest pay in that job to the highest pay in that job, as long as you have a good faith belief that you might pay the candidate somewhere in that range. How long do you have to post the vacancy? So we don't have clear guidance on this. This really goes to the good faith part of the Act, where you have to show good faith compliance with these rules. And so posting something for 2 hours so that you only get one applicant and it's the one applicant that you want, it's probably not going to cut it. But you also don't need to keep the posting up for an entire month if you get the candidates you need within the first week. So hopefully we'll know more about where the boundaries are soon. We'll keep checking those fact sheets. But for now, the best answer to this question is use your good faith, good judgment. And then finally on this slide, what to avoid during job interviews. So key here, critical, can't stress it enough. You cannot ask about past wage history. If somebody tells you what they're making in their previous job, you can't rely on it to set their new salary. You can't ask for their past wage history. If somebody refuses to talk about their past wage history, you can't retaliate against them and refuse to hire them. So that's the key thing to stress during job interviews. Okay.
Deborah, I've got a question. So on the compensation range issue, are you hearing a lot of angst from employers about that, having to post, well, this is the range of what we pay people, and then that's going to signal to some of our existing workers that they're, at the bottom end of the range, and so forth. So are you hearing concern about that?
I am. I'm hearing companies try to craft ways around this requirement, mostly unsuccessfully. Somebody asked me if they could post just that they were seeking an hourly rate or a salary rate. And that's not going to cut it. That's so vague. It doesn't comply with the good faith requirement. And so the answer is yes, there is angst. There's not a way around the angst. These job posting requirements are pretty onerous, and they apply just to Colorado. So for companies that have multi-state operations, they're harder to line up with what they're doing in other places. All right, I want to move on to the pay audit. So Luke, can we put up my last poll question, please? So just want to get a sense of the audience here. So whether you're at a place that's conducted a pay audit, when it happened, or if you don't know if there's been a pay audit. So while you're answering that, let me just talk about what pay audit does. So this measures inequity in the workplace. You'll see if you're paying people of different demographics differently. You have to make sure that you're paying across job bands equally, especially now that we've got this requirement that you need to pay equally for substantially similar work. And so you'll want to get HR, your attorney, finance, everybody involved in the process, and then reviewing the results. And this will help dictate if you're paying the market rate at the entry level where you're hiring, but also you can track whether you're paying people equally in terms of raises, promotions, bonuses. So you can see where potentially discriminatory decisions are being made. All right, Luke, let's close the poll, please. Okay. Great. So it sounds like a decent number of people are places where they've done a pay audit. And I asked whether you've done the pay audit in the last 2 years, because that's important from a legal perspective. Of course, a pay audit is great from a morale perspective as well. So you can remedy results that are potentially discriminatory. But from the legal perspective, if you're violating the Equal Pay Act, there are pretty heavy damages. You may have to pay 3 years of back pay, up to $10,000 for posting violations, attorney's fees, economic damages. And then those economic damages can get doubled when you add in liquidated damages as well. But if you've done the pay audit in the last 2 years before the lawsuit's begun, that can be evidence of good faith, which is a defense and can limit the amount of damages that you are liable for. So the takeaway here is do a pay audit as frequently as you can, and then take action after you get the results from the pay audit. Okay, and with that, I'm gonna hand it over to Brad.
Great, thank you. And let me reiterate, if anyone has questions, feel free to put them in the Q&A and we'll try and answer them otherwise, after the presentation. We don't get to them now, but otherwise, absolutely jump in and interrupt us. We want to have this be productive for you and try and answer your questions, including with respect to topics we've covered, the Equal Pay Act. We can go back if you want. The last topic that we want to hit is the HFWA, the new paid sick leave law in Colorado. This went into effect January 1. I imagine everyone has a general idea of what it requires. Broad strokes, it requires that you provide 1 hour of paid sick leave for every 30 hours worked. up to a 48-hour limit. That accrued leave has to carry over year to year, again, up to that 48-hour limit. And then the second part of the law creates specific paid sick leave when there's a public health emergency like there is now. When there is such an emergency, you have to supplement the amount of paid sick leave that people have up to 80 hours for people who are working full-time, or a lesser amount for people who are working part-time. And that public health emergency leave has to be available throughout the duration of the public health emergency and for 4 weeks thereafter. Luke, if you could put up my first poll question. My first poll question is asking you guys how you're doing providing this 48 hours. Are you letting it accrue pursuant to the 1 hours per 30 worked, or are you perhaps front loading it? Because that seems to be really one of the first big decision points that employers are facing in this. And most of the employers that I'm advising are choosing to front load as opposed to have the time accrue, but there are advantages and disadvantages to both. Luke, could you maybe tell us the results on this already? No answer. Interesting. So maybe folks are undecided on this, or maybe they're not up to speed on the law yet. You know, I think for a number of reasons, front loading the time tends to be a lot easier. You're not tracking time that people are working. You're not dealing with those situations where someone is exempt. How do you track the time that they're working? If someone is paid on a fee for service basis rather than hourly, how are you tracking their time? The regs do address all those things. It can be done, but I think the majority of employers, like we're seeing here, at least amongst those who have answered, are front loading the time. And you know, there are some issues with front loading, of course. You know, one being and by front loading I mean you give everybody 48 hours at the beginning of the year. If you do that, you know, of course, someone could take all that time and leave mid-year and end up having more time than they would be entitled to had it been accrued. But that's really the only major downside of it that I see. You know, there is maybe one trap that I've seen for folks who are front loading, which you may or may not have given thought to, is a lot of employers will say, well, you know, we want to front load the full 48 hours. And if someone joins mid-year, we're just going to prorate that amount. And that's generally safe, but you have to double check yourself, because if someone joins, let's say, right in the middle of the year and they get 24 hours, that may or may not correspond to 1 hour for every 30 hours worked through the end of the year. It's going to depend on their schedule. So be wary of just kind of automatically prorating. You know, accrual issues maybe are more problematic, as we discussed. And I think one of the main issues I see with accrual is this new public health emergency leave. So, you know, you have to supplement the amount of pre-existing accrued normal leave up to this 80-hour limit when a public health emergency is declared. But you also then have to let people continue to accrue their normal leave. And so if you do go down the path of accruing rather than front loading, you know, people are going to start out with a bank of basically 0 hours of normal health leave, automatically get 80 full hours of the public health emergency leave, and then will continue to accrue their normal leave. And so you may end up having people do more leave overall. I'm trying to check questions and answer as well right now. Someone's saying they accrue pursuant to an existing PTO policy. That's interesting. I do want to talk about PTO policies in a second. And someone else is saying they accrue. Very interesting. Is anyone on the line at a unionized employee, or excuse me, a unionized company that has a CBA? Anyone's had to deal with CBA provisions? Feel free to speak up if you have.
Yeah, I am, and we, you know, it's something that we've been addressing with, I think, maybe more than one MOU to this point.
Right. Well, and that's what I've experienced too. You know, the act says if the CBA already provides for equivalent or more generous benefits, you don't have to comply with HFWA. But as a practical matter, we're finding that employers who are unionized will often, you know, go to their union and say, look, for example, you've got a vacation article, let's try and change it to make it HFWA compliant, or maybe even you have a sick leave article, let's try and change it. And we're seeing that the unions are well aware of their rights under this new law, aren't willing to change. And so you're often just adding the sick leave on top of pre-existing leave that may be provided in a CBA. Or, you know, if you're lucky, and it sounds like whoever was speaking has had some success with their union. If you're lucky, you know, the way you can do this is through MOUs, you know, change the CBA. But we're finding a lot of unions aren't really playing ball on this issue. Let me advance to the next slide. And actually, let me advance one more since we're running a bit out of time. And I bet this issue, this third issue, may be one of the bigger issues on people's minds. And Luke, if you wouldn't mind putting up the polling question while we start talking about this third issue, which is using your PTO policy as your HFWA policy. And the question essentially we're going to ask you is, it's that second one you see there. Is your company using a paid time off policy to comply with the HFWA, or is it providing paid sick leave separately? I'm very interested in knowing what people are doing here, and taking a step back, the Act does say that if you have a pre-existing paid time off policy that allows both sick leave and vacation, you can use that policy with some very important caveats. And those, and someone may be trying to say something. Feel free to interrupt me. Perhaps not. That's background noise. The caveats really are that your pre-existing PTO policy has to provide the same amount of leave, have it accrue in the same manner. It has to be used for or available for use for all the same reasons as HFWA leave. It can't be, you can't have more restrictions on the use of your PTO than the HFWA would allow. And that's really a big one. You know, the HFWA says things like, essentially, employees don't need to provide notice if they're taking leave. Or putting a finer point on it, they do have to provide notice if it's foreseeable, but if they don't provide notice, you still have to provide them the leave. You know, similar issues with documentation. You know, you can't ask for documentation unless leave is 4 or more consecutive work days. And even if it is, the types of documentation that you can ask for are pretty limited. And so a lot of employers are concerned, I've found, about using their PTO policy as their HFWA policy, because it may mean getting rid of all those restrictions that you may have in your PTO policy, all those notice restrictions, documentation restrictions, and you know, recitation saying that leave can only be scheduled with management approval. Luke, could we see the result of that poll, please? Interesting. So, so it looks like 19% of you are trying to use your PTO policy that way, you know, probably encountering those issues I've described. 33% of you are providing paid sick leave separately, which is definitely easier. If anyone who is providing the PTO policy wants to speak up and tell us if you've encountered any of these issues that I'm describing and how you've tried to get around them, that may be useful for the group. And the issues I'm talking about are, you know, taking out some of the restrictions in your previous PTO policy and making it, you know, really much looser than it was before. Is that causing anybody problems? Are you seeing abuse of leave by doing that?
Yeah, hi, this is Jonathan again. Sorry, did I cut somebody off?
No, absolutely. Go ahead.
Okay. You know, my answer was we use a PTO policy, but it's a little bit, I kind of needed to answer both ways because as I was saying, we do have a unionized workforce. And for that group of employees, there's a paid sick leave. Sick leave and vacation leave are separated out for those employees and under our CBA, but our salaried administrative staff is on a PTO program. And so for that staff, we do just kind of roll this into, you know, the PTO policy as it previously existed, but we also have had to deal separately with issues related to a leave abuse and, you know, the issues with documentation with our represented workforce. And I think that's been the biggest headache for our managers and supervisors thus far.
Yeah, and you know, I've heard the exact same thing. A lot of people were concerned at the outset of doing this because they thought there'd be this leave abuse, and then on the back end, they're in fact seeing some. So it's interesting to hear your perspective as well. I'll throw this out for discussion, and I don't have an answer to it. But you know, some employers are asking whether, assuming they use their PTO policy as HFWA policy, can they really have separate rules even within the PTO policy for vacation time versus sick leave time? You know, can they retain some, say, management approval requirements for vacation time, but not have it for sick leave time? And that's, you know, that's an interesting approach. And I said I don't have the answer to it because the way the regs are written and the statute itself, for that matter, it seems to suggest that the legislature and the agency were really thinking of having, you know, one PTO policy with one set of rules that applies both to vacation and to sick leave. However, on the other side of the ledger, if you were to have kind of one of these hybrid PTO policies where you have different rules for the vacation piece of it than you would for the sick leave piece of it, it's hard to imagine what kind of damages someone might have if, you know, if they're allowed at a minimum to take their sick leave under all the conditions that the HFWA provides. You know, are they damaged if the PTO policy writ large says, you know, but you still have to jump through these hoops for vacation? So keep that in mind as something you may want to kick around. There's not, you know, obviously none of this has been litigated yet because it's so new, but that may be an option that folks could think about. I do see in the Q&A, somebody asked me a question: does the public health emergency leave apply to employers with fewer than 16 employees this year? And the answer to that is yes. The law generally only applies to employers that are 16 or more this year, although it opens up to everybody next year. But I believe there's an exception for employers, for all employers having to provide the public health emergency leave this year. And I said the answer is yes, but let me footnote that and say I'm reasonably certain. I know where the answer is, and I can tell you the answer is in one of those fact sheets that I talked about before, an info sheet number 9, I think it is, that talks about, or actually maybe 6C. I think that's right. And Deborah may know off the top of her head. Well, we'll get you a correct answer on that one in a follow-up email. I think the answer is yes. I seem to recall that they did open it up, the public health emergency leave, exclusively, not everything else, to smaller employers this year. But let me double check on that and we'll respond in a separate email. Let me, since we just have a couple minutes left, let me just hit one last issue. Payout of vacation time. This is something that's been percolating for a while. The status of the law right now is that there is a regulation in place which essentially says once employees earn or accrue vacation time, it always has to be paid out at separation. It always has to roll over year to year. You can't have use it or lose it policies. However, that regulation may or may not be overturned in a case before the Colorado Supreme Court right now. It's a case called Carmen's v. Clark Market, or excuse me, Carmen Nieto v. Clark's Market. It was a case that was heard in December We're waiting the court's decision right now, so put a pin in that. But for now, there are regulations saying you do have to pay out vacation time. That could change shortly. I know we're right up about on 1 o'clock, but if anyone wants to jump in right now and ask any questions of any of us, we're happy to answer them. I'm not hearing questions, and I'm not seeing new ones coming in on the Q&A. I think it was Linda who asked me that question about public health emergency leave applying to employers with 16 or fewer. So Linda, I'll follow up with you and tell you the answer on that. But as I say, thank you for everyone for joining us. We are glad to have this opportunity to talk to you. If you have more questions, email us. Otherwise, hopefully some of you were able to join our previous discussions. And if not, there's one more next week, but I think it's like this one, it's a limited participation so that we could hopefully have a dialogue with folks. So you may not be able to get in, but it'll probably be the same topics we're covering today, so you won't miss anything. But thanks again. Email us with questions. Thanks.
Thanks, everybody.
Thanks.